Consulting contracts are the foundation of successful professional relationships between consultants and their clients. Without proper legal documentation, both parties risk misunderstandings, disputes, and financial losses. Today, we're exploring the essential elements of consulting contracts for legal services and providing key tips to protect your interests. A consultant contract becomes necessary whenever a consultant enters into a business agreement. Consultants, also known as contractors or freelancers, are professionals who provide specialized advice or services to companies or clients in exchange for compensation. They typically specialize in specific areas such as engineering, human resources, marketing, or legal services. At its core, a contract is a legal document between two parties involving an exchange of value. When something valuable like goods, money, or services is exchanged for something else, such as consulting expertise, the agreement constitutes a contract. The complexity of the task doesn't matter. Contracts apply to both simple, quick services and complex, time-consuming projects. These documents can range from a single page to over 100 pages, depending on the complexity of the arrangement and what needs to be defined. Every legally binding contract must contain three key elements. First, there must be an offer, which is something proposed by a business or individual. Second, there must be acceptance, where one party accepts the terms offered in the contract. Many contracts include time limits, stating that offers expire after a certain number of days unless signed and accepted. Third, there must be consideration, which refers to the payment amount for the services. For example, a contract might state that services will be rendered in exchange for $500 per month. A comprehensive consulting agreement includes several important components. It should contain contact information for both the service provider and the customer, including correctly spelled full names and titles. The agreement should list project goals and endpoints, clearly define the services being provided, and outline the consultant's responsibilities. Creating checkpoints where clients sign off on completed phases can ensure satisfaction with the work. The contract must detail compensation, including when and how much the company will pay the consultant. Additionally, a confidentiality agreement prevents consultants from disclosing private information, like client lists, trade secrets, and marketing strategies. For legal services consulting specifically, certain clauses are critical. The scope of services must precisely define the nature of the legal or advisory work to prevent misunderstandings. Deliverables and timelines should specify what will be provided and when, including benchmarks for long-term projects. Compensation and expense clauses should clarify rates, billing frequency, reimbursable expenses, and payment terms. Confidentiality provisions are especially important when consultants access sensitive client information. Intellectual property rights must state who owns work products developed during the engagement, with clients typically retaining ownership. Non-compete and non-solicitation clauses can prevent consultants from working with competitors or soliciting employees for a defined period. Termination clauses should outline how the agreement can be ended, including notice periods and severance terms. Finally, dispute resolution provisions define how disagreements will be handled, whether through mediation, arbitration, or court proceedings. Consulting contracts in legal services take various forms depending on the engagement type. Project-based agreements are defined by specific project scopes and end once completed. Retainer agreements involve recurring fees for a set number of hours or general availability. Hourly consulting agreements work well for clients needing occasional advice who prefer paying only for time used. Advisory board or fractional counsel agreements apply when consultants serve as part-time general counsel. Compliance and regulatory advisory agreements focus on helping clients meet ongoing regulatory obligations in areas like securities law or healthcare. Legal consultants operating in highly regulated industries face additional contract requirements. Compliance representations may require consultants to affirm they aren't under investigation or disbarred. Licensing and qualification clauses include proof of proper credentials for offering regulated legal advice. Insurance requirements might specify professional liability coverage or errors and omissions insurance. Record-keeping obligations detail how and for how long consultants must retain documentation for compliance audits. While templates offer starting points, consulting contracts should be reviewed or drafted by attorneys, especially for legal services. Attorneys ensure enforceability across jurisdictions, tailor language to unique risks, like data breaches or compliance violations, help negotiate protective terms, and identify ambiguous clauses that could create loopholes. Understanding the fundamentals of consulting contracts helps protect both consultants and clients. These agreements clarify services, establish expectations, outline compensation, and provide legal recourse if disputes arise. Whether you're a consultant offering services or a business seeking expertise, a well-crafted consulting contract forms the foundation of a successful professional relationship while minimizing legal and financial risks for all parties involved.